In Court on TKO8 Television is brought to you in part by Campbell Bonding Company. Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138.
I'll call Frank Salvador Compton. Mr. Compton, you're appearing here in court this morning for what's called a Rule 8.1 hearing. What I'm speaking of in terms of Rule 8.1 is Rule 8.1 of the Arkansas Rules of Criminal Procedure. Provides that when an individual is taken into custody and being held and not able to and has not made bond, they're entitled to promptly be brought before a judge, and I happen to be the judge that's available this morning. The purpose of bringing you before the judge is to first of all make sure you understand why you're being held, what the charges are. Second, to be told of any bond that's been set in your case. And third, to be informed of certain constitutional rights that you have. This court is going to advise you at this time that you were picked up on a citation, a charge of public intoxication, usually the tickets say, okay, your court appearance in Boone County District Court is set for July 26th at, well, you need to check with the court. I can't read. It's sometime 30 p.m. I guess that's I'm going to say that's 1:30, but I don't know. You need to check with the court and find out the hour of that appearance on July 26th and make sure you get there. If you bond out, of course, you'll be responsible for getting there and being on time. If you don't bond out, then you'll have transportation that'll get you to court. Now, so that's what you're charged with. Your bond has been set at $370 cash or professional bond. First of all, let me just quickly ask you your date of birth. What is your date of birth?
Frozen right now, Judge.
What is your date of birth, sir? Huh?
1/1866.
All right. And court would advise you of your rights. The two rights that are most important at this point in your process is to inform you, first of all, you have the right to remain silent. What that means is you simply have the right to decline to answer any questions if law enforcement asks you them. You're not required to not answer questions, but you have the right to refuse if you choose to. The second right that you're informed of is that you have a right to an attorney. In terms of your right to an attorney, what that means is that you have the right to hire the attorney of your choice, and the court doesn't get involved in that in any way. That's a private contract between you and the attorney you choose to hire. If you cannot afford to hire an attorney, you still have the constitutional right to be represented by an attorney. And if you want to exercise that right, then when you discover you can't afford to hire an attorney, then you should you'll need to look for and obtain a copy of the application for the Public Defender's Office, fill that out and sign it, and turn it in. Applications are available there at the jail. If you get out on bond, you can go by the Public Defender's Office, or I believe the district court has copies of those applications to fill out if that's what you choose to do. In any case, you need to fill out an application before a court will be able to appoint the public defender to represent you. Do you understand these rights I've just been over?
Yes, Your Honor. I was, do you know the bond, $370?
$370, yes, sir.
I was hoping I could pay some of that today, and you could OR me today, so I could run and get the rest, and I could pay the courts and still make my court date.
I'm not going to OR you. This is a district court charge. That's the bond that's set by the district court. You'll have to make your arrangements with the district court on posting that bond. In other words, that's something that's set by the district court, and I'm not. I don't change that judge's bonding system. So.
Okay.
Okay,
thank you then.
All right, you may be excused. Call Brittany Sudduth, or Brittany Shirley Sudduth. Are you Miss Sudduth?
Yes, sir.
What's your date of birth?
82 of 85.
Okay. You've been, once again, I just advise you that you're before the court for what's called a Rule 8.1 hearing. Rule 8.1 refers again to Rule 8.1 of the Arkansas Rules of Criminal Procedure, and that rule provides that someone who's been taken into custody and hasn't been able to make bond is entitled to promptly be brought before a judge to make sure they're informed of the charges against them and the charges against them and any bond that's been set. The court is looking at you were picked up on an arrest warrant issued out of Boone County District Court. I guess this is for failure to appear in district court. You had obligations, fines, and probation costs that you had stopped paying on. At the time the warrant was issued some time ago, The warrant sets a bond of $1,278.04, and that's a cash-only bond. However, there's a notation on this warrant indicating that that bond has been reduced to $300 cash only, and so that's the bond, is $300, but it's a cash-only bond. I think that's what it means. So that's what the court is noting for you. Once again, while you're in custody, the court is advising you of your constitutional rights that are important to you while you're in custody, and those are, first of all, you have the right to remain silent and not make any statements against your interest. How you exercise that right is if you're attempted to be interviewed by a law enforcement officer, you may decline to answer any questions. You do that by just telling him you're not going to answer any questions. Your other right that you have is your right to an attorney. Court would advise you that that's a constitutional right that you have. The way you exercise that right is you go out and hire the attorney of your choice. That's a matter of private contract between you and the attorney you're hiring. The court doesn't get involved. If, however, in the process of trying to secure an attorney, you discover you cannot afford to hire an attorney, then you still have the right to an attorney, and the way you exercise that right at that point is you seek and obtain, they have them there at the jail, you get an application for the public defender's office. I think the thing's locked up. I don't think it's.
Sam.
All right, can you hear me?
Yes, sir.
Okay, the way you get an attorney, if you can't afford to hire one, is that you make application to the public defender's office. Those applications are there at the jail. You ask the jailer for one, fill it out and sign it, and that'll be processed. Turn it in and it'll be processed through, and an attorney, upon review of that application, will be appointed to you. Do you understand these rights? Do you understand the rights I've just explained to you?
Yes, sir.
All right. All right. You may be excused at this time.
Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138. Inland Waste Solutions works diligently to be good stewards of the environment. Reducing waste via curbside recycling services, Inland Waste Solutions takes this mission seriously, but they need your help. When putting your waste and recyclables in their respective curbside containers, be sure that cross-contamination doesn't occur. Please only place recyclable materials in the yellow top bins. Check your recycling do's and don'ts list before you throw any item into the yellow top recycle bin. Together we can make a difference. Inland Waste Solutions, local people serving local people in Harrison.
Stop in at White Oak Station on Capps Road in Harrison and fill up with Shell gasoline, the highest quality gasoline with more miles per gallon, saving you money. Sign up for the Fuel Rewards card and save 5 cents per gallon every time. Plus, get an extra 5 cents off on Razorback Wednesdays. That's a savings of 10 cents per gallon. Check out their expanded deli and hot and cold food items. Capps Road, White Oak Station, where customer service is their #1 goal.
2008 Boone County case 2018-222, State of Arkansas versus Jesse Benton.
Judge, she has made application.
All right. Court is making the appointment of the Public Defender's Office to represent Mr. Benton. All right. On the charges, this is for arraignment on the charges of battery in the first degree, Class Y felony, battery in the second degree, Class D felony, domestic battery in the second degree, a Class C felony, interference with a law enforcement officer, Class C felony, 2 counts, all charged as an habitual offender. On those charges, how does the defendant now plead?
Not guilty, Your Honor.
The plea of the defendant of not guilty is noted. This case is assigned to the Division 4 docket and will be scheduled by scheduling order. Scheduling order will provide for the defendant to be set for trial during the week of March 11th of 2019. March 8th will be set as a plea deadline date to accept any pleas. February 8th of 2019 is set as a pretrial date, and the defendant's ordered to reappear on November 2nd. That will be the next time he's ordered to appear in court. At that date, we'll check on the status of the case. Any other matters to come before the court in regard to Mr. Benton?
Judge, for the record, he has another case that is coming down the pipeline. I've made a plea offer that covers both cases, and in this case, 2018-222-4, this morning I delivered discovery to the defense.
All right. All right. Mr. Benton, the Public Defender's Office has been appointed to you, and your case has been set down by scheduling order, as I indicated. That scheduling order will be in the court record. Our records are in this jurisdiction are digital in nature, that is, they're online, and there is a public access to that scheduling order. That if you had access to a computer, you could look up those in something called Public Court Connect. Now, the important date for you to keep absolutely in mind is that November 2nd of 2018. That's the next time you're scheduled in court. If you make bond and get out, it's your responsibility to be in court on that date. And failure to do so will result in a warrant being issued. If you get out, you're also under an order, according to that scheduling order, to get in touch and stay in touch with your attorney. Mr. Burnett, who's here in court, is your attorney, been appointed by the court to represent you. While you're in jail, I expect him to come talk to you and get started working on your case. But if you make bond, it's no longer his responsibility to track you down. I am ordering you to get in touch and stay in touch with him. So if you make bond, I'm ordering you to make contact with the Public Defender's Office as soon as you get out, schedule an appointment with the Public Defender's Office, and get in to see the Public Defender. Your failure to do so can result in you being held in contempt of court. I want you to understand, I'm very serious about that. It's your job to stay in touch with him. Do you have any questions at this point?
Yes, Your Honor. I would like to know if I could get a possible reduced bond.
$500,000. Judge, that's only $500,000 on this case, and as I told the court, he has a charge coming down of delivery of methamphetamine of 12.3 grams.
Judge, we can take bond up at his next hearing. If he has another case pending, then a reduction here would be pointless at this time.
Well, that's going to be the finding of the court, is if Mr. Carter says there's another significant charge in the works, you know, whatever I set for bond here is going to be, have to be relooked at. But I'm not going to reduce the bond at this time. So,
Your Honor, I have never delivered methamphetamines. I don't know
Well,
where that's in.
we're not going to take up the trial of your case here today and determine that one way. That's so you say. Obviously, the prosecutor's office intends to claim you have. So we'll take that up when we get to the trial. So the issue here today is you've asked me to consider bond, and I'm going to tell you I'm not going to, at the current time, I'm not going to reduce the bond. The bond that's been set is, at this time, is $500,000. So that's the bond that's been set. You may be excused. 2018-195, State of Arkansas versus Travis Blackwell. Mr. Blackwell, I'm reviewing an affidavit for the Public Defender's Office. You list yourself as self-employed. What kind of business are you self-employed in?
I just do construction work, Your Honor.
All right. But you don't have a regular income?
I varies. No, sir.
All right. Based upon a review of the affidavit in this case, the court is making the appointment of the Public Defender's Office to represent Mr. Blackwell. All right. Mr. Blackwell's for arraignment on a charge of possession of a controlled substance, Schedule 1 or 2, a Class D felony. Mr. Blackwell is charged in this offense as an habitual offender. On those charges, how does Mr. Blackwell now plead?
Not guilty, Your Honor.
Court notes his plea of not guilty. This case is on the Division 3 docket of Judge Putman. I'm going to set him down to reappear on July 20th. Mr. Blackwell, that's your next date to reappear in front of a judge. That'll be in front of Judge Putman on July 20th to get you set on his trial schedule, because you're assigned to Judge Putman's docket. The court will advise you that bond has been set in your case at $10,000. That's a cash or surety bond. If you make bond, it's your responsibility to be in front of Judge Putman 2 weeks from today on July 20th. And it's also, with the Public Defender's Office appointed, it's your responsibility as soon as you bond out to get in touch and stay in touch with the Public Defender's Office. That means you'll be required to contact the Public Defender's Office and to make an appointment to get in and see the Public Defender. I'm anticipating that the Public Defender will be appointed to represent you will be Ben Gibson, who's not here today. So that's, if you get out, that's who you can expect to either hear from at the jail or if you get out, who you'll be expected to make an appointment to get in to see. Do you have any questions at this point?
No, sir.
All right, you may be excused.
Hi, this is Ashlyn Taylor of Valley Springs, and I'm proud to be a Lady Pioneer. I chose North Ark first because it's close to home and I like the small class sizes and helpful staff. I'm working on getting my general education classes completed so I can transfer to a university. I'm excited to be playing basketball at the college level while getting an excellent education at an affordable price.
Enroll now for fall classes. Classes start August 20th. For quality, value, and convenience, pick North Ark first. We're your college.
We all need the help of a pharmacy from time to time. Sullivan Pharmacy would like to thank all their customers for supporting them as an independent local pharmacy. When you trade with an independent pharmacy, you deal with an owner that supports the local economy and charities. Visit Sullivan Pharmacy for any of your over-the-counter or prescription needs. It's important to keep helping those that help the community. Sullivan Pharmacy, 731 Main Street, Harrison, serving this area since 1965.
Many things have changed over the years, and so has auto body repair. Even though Ozark Auto Body has been in business for over 30 years, they continue to change with the times. They believe protecting the environment is important and have done so by using environmentally friendly waterborne paint from PPG. This aligns with the technology used by original manufacturers and gives you a lifetime limited warranty. Quality PPG waterborne paint, ASC certified personnel, plus 24-hour towing service. Ozark Auto Body in Harrison, always taking pride in excellence.
Court will call 2018-231 State of Arkansas versus Jason Glover. Good morning. Upon review of the affidavit, the court is making the appointment of the Public Defender's Office to represent Mr. Glover. Mr. Glover is for arraignment on charges of delivery of methamphetamine or cocaine, a Class Y felony, simultaneous possession of drugs and firearms, a Class Y felony, possession of a controlled substance, Schedule 1 or 2, Class D felony, theft by receiving, a Class A misdemeanor, and an enhancement provision about proximity to certain buildings or facilities. On those charges, how does the defendant now plead?
Not guilty.
Plea of not guilty is noted on his behalf. So once again, his case is assigned to the docket of Judge Putman, that is Division 3, and the court is ordering him to reappear in front of Judge Putman on July 20th in order to get on Judge Putman's scheduling order.
Is there any way I could get my bond reduction?
Judge Putman specifically set his bond at $20,000 cash only.
I didn't get past the funds.
All right. The judge, you can take that up, the issue of a bond reduction with Judge Putman. The documents do reflect that it's a $20,000 cash only bond. as set by Judge Putman. And you'll be in front of him in 2 weeks from today, and you can take it up at that time with him. If you make that bond and get out, it's your responsibility to appear on July 20th in front of Judge Putman. Court would also advise you, with the Public Defender's Office appointed, it's your responsibility to get in touch and stay in touch with the Public Defender's Office. Now, as long as you remain in jail, I would expect the Public Defender to come see you within a week to 10 days at least, get out to see you and get started working on your case. If you bond out, though, that changes, and it then becomes your responsibility to actively seek them out and make contact with them. You do that by calling the Public Defender's Office within 24 hours of getting out and making an appointment to get in to see the Public Defender. Appointed in your case more than likely will be Ben Gibson, and you need to get in touch and stay in touch with him once you get out of jail. Do you understand this?
Yes, sir.
All right. You may be excused at this time. Court's going to call 2018-235, State of Arkansas versus Michael McElroy. Mr. McElroy, you're for arraignment today. Before we get to the arraignment, have you made any arrangements to be represented by an attorney?
No, I'd like to apply for public defender.
Okay. Those applications are available there at the jail. You ask the jailer for one, fill it out and sign it and turn it in, and it'll get to the Public Defender's Office, who'll make sure it gets in front of a judge and gets reviewed for the appointment. That's how that process works. So, but you need to get the application and fill it out and sign it before that process can go any further. So that's what you need to do. I'm going to note that you're applying to the Public Defender's Office. Now, on the charges against you, which are residential burglary, that's a Class B felony, theft of property, a Class C felony, driving on a canceled license, that's an unclassified misdemeanor, theft of property, a Class C felony, and then a separate charge of theft of property, a Class C felony. On those charges, how do you now plead?
Not guilty.
I'm noting your plea of not guilty here on the record. Your case is also appointed to the Division III docket of Judge Putman, and I'm ordering you to reappear in front of Judge Putman on July 20th. All right? Now, what that means is that you'll be, if you're still in jail, you'll be in front of, probably through this same medium of Skype, you'll be in front of Judge Putman to get on his scheduling order. If you get out of jail, however, it becomes your responsibility, because I've now ordered you to reappear on July 20th. It'll be your responsibility, if you bond out, to get to court on July 20th. That's 2 weeks from today, and be in front of Judge Putman. So that, I'm just making sure you understand that that's your responsibility to make that court appearance under those circumstances.
Your Honor, I'm
Yes,
currently a federal inmate. I'm back for court in Carroll County. So I got court on the 16th. After the 16th, they're taking me back to my federal prison. I don't know if that's going to cause problems or...
Well,
Judge, to be honest, he did write us a letter asking us to get this thing squared away, because we did not know that he was in Carroll County. Actually, we didn't know he was in federal custody. So if we set him for reappearance on the 13th, we might be able to get his matter resolved before the feds take possession of him again. Because we don't have permission from the feds to hold him, at least not at this point. And I talked to Mr. Bradford about that. But I do know he wants to try to get this resolved because he did write us a letter.
Your Honor, I get out of federal custody August 10th.
Oh, well, then it becomes a little less of a problem.
Well, are you still requesting we have him reappear on July 13th?
If I could get it set for August, around August, a little bit after August, I'd greatly appreciate it, so I can get my federal stuff taken care of.
Well, has he hasn't been arrested on this case previously?
No. In fact, we resolved this case through DNA analysis. This actually occurred 2+ years ago, and we got the DNA results in 2017 and filed the case in 2017.
Well, so I know that's what I'm debating on. So I'm going to go. Then here's what I'm going to do: is I'm going to set you down to reappear. Make sure I've got the. I'm setting you down to reappear not on July 20th in front of Judge Putman, but on August 24th in front of Judge Putman. Okay? Now, again, I'm telling you, if you're out, you get your matters in federal court out, and you get out, it's your obligation to get to court, and you've now been ordered to appear on August 24th in front of Judge Putman. Okay? So I don't know, you make a note, whatever you need to do to remind yourself that it's your obligation to be there on that date. If you're still in federal custody, then it'll be the prosecuting attorney's problem to make arrangements to get you back to state court and proceed on the case. So that's what I'm ordering, is that you're to reappear in front of Judge Putman on August 24th to get on his scheduling order. All right? You may be excused.
Thank you, Your Honor.
Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138. Inland Waste Solutions works diligently to be good stewards of the environment. Reducing waste via curbside recycling services, Inland Waste Solutions takes this mission seriously, but they need your help. When putting your waste and recyclables in their respective curbside containers, be sure that cross-contamination doesn't occur. Please only place recyclable materials in the yellow top bins. Check your recycling do's and don'ts list before you throw any item into the yellow top recycle bin. Together we can make a difference. Inland Waste Solutions, local people serving local people in Harrison.
From the makers of the best-selling Yamaha Grizzly and Kodiak 700 comes the all-new Kodiak 450, the world's only midsize ATV with Yamaha-proven off-road capability, all-day comfort, and confidence-inspired performance. The all-new Kodiak 450, starting at just $59.99.
2018-230, State of Arkansas versus Amber Vaughn. Ms. Vaughn, you're appearing here today for purposes of an arraignment on charges of possession with the purpose to deliver a controlled substance, Schedule 6, possession of drug paraphernalia, the first is a Class C felony, the second a Class D felony, also possession of drug paraphernalia, Class A misdemeanor, and possession of Schedule 4 or 5 controlled substance, another Class A misdemeanor. Have you made any arrangements to be represented by an attorney at this point?
I filled out the public defender form here in the jail.
And you turned it in?
Yes, sir, to Sergeant Brock
When did you do that?
a couple days ago.
Yesterday morning, I called to the jail and talked to Jason Silva. I named off everyone on the list that I needed applications for. When he took it back to her, she informed him, I guess, that she had an attitude, she didn't want to fill it out yesterday. I didn't go out for 2 hours. When I went out yesterday is when Jason said that she wasn't in the mood to fill it out, so it wasn't there when I picked him up at 11:30 yesterday.
Okay.
Your Honor, Jason Silva's sitting right here beside me shaking his head no. That absolutely did not happen.
Well,
Even you saying it didn't happen.
all right. Here's what we're going to do. Let's find out where that form is. I'm not going to get in the middle of this. I'm not going to get in the middle of this. If you filled it out, then let's find out where it is. Talk to Jason about where it is. You know, it's the jail's responsibility once you turn them in to keep up with them. It needs to get to the public defender's office. So that's what needs to happen. If you cannot find it, then fill out another one. It won't hurt you to fill out and sign another one and get it turned in, because that's what's necessary to get the appointment made. Appointment of attorney can't be made until you filled it out. I'm noting the fact that you are applying to the public defender's office on the charges of possession with the purpose to deliver controlled substance, marijuana, Class C felony, possession of drug paraphernalia, methamphetamine or cocaine, Class D felony, possession of drug paraphernalia, Class A misdemeanor, and possession of controlled substance, Schedule 4 or 5, Class A misdemeanor. On those charges, how do you now plead?
Not guilty.
I'm noting your plea of not guilty. You are assigned to this court's docket. An order has been entered that sets your case, a scheduling order has been entered of record. It sets it for March 11th. Trial week is March 11th, 2019. Your plea deadline date is March 8th of 2019, and your pretrial date is April 8th of 2019. Excuse me, February 8th of 2019. Before you start talking, can I finish making a statement telling you about your trial dates? And then we'll discuss what you want to discuss, okay? I'm making a record that you're set for trial the week of March 11th. Your plea deadline date is March 8th, both of 2019. You've got a pretrial date of February 8th of 2019. And your next reappearance in court is scheduled for November 2nd of 2018. Now, all of those dates are down in the record, and you need to make sure you're in court the next time on November 2nd. The reason I bring that up is if you were to make bond and get out of jail, it is your obligation. You are ordered to appear on that date. So make sure you know that date if you get out, because it'll be your responsibility to get to court and not be confused about that. Now, what did you want to bring up?
Well, I was going to ask for a bond reduction, and I have cases in front of Judge Putman I was going to ask that this be combined with.
She's correct. She has case 2018-83 and 2018-123, both in front of Judge Putman.
What was it, 18 what?
83 and 18-123.
Okay. At defense request, then the court will transfer this case, 2018-230, to the Division III docket. to be combined with those. So I will cancel, I'm going to cancel that scheduling order I just read off. Your next appearance date in court is now, you're ordered to reappear on July 20th in front of Judge Putman. So if you bond out, it is your obligation to be in this courtroom in front of Judge Putman on July 20th to get on his scheduling order. You understand?
Yes, sir.
All right. If you're in jail, arrangements like this can be made to get you back in front of him. Now, you asked for a bond reduction. Let's look at that issue. Mr. Carter, what kind of bond has been set in this matter? I don't find it on either the affidavit or on the information.
Nor do I, Your Honor. I have no idea what bond may or may not be set in this particular matter.
Is there a...
I'm trying to see if I can find whether she had an 8.1 hearing where
that's what I'm
bond may have been set. Jason, do you know if she has a bond?
It's not on the bench, service of the bench warrant, wasn't noted.
Okay. 35,000 is what they're showing.
Is that covering all 3 cases or just this case?
I'm not sure. I'd have to go to my office and get on the computer. This one's not tied to the jail management system. All I got's a printout.
Well, let's... Ms. Vaughn, is it your opinion that your bond is $35,000?
Apparently, Your Honor.
Okay.
It's a little high for Class C and Class D.
Who set that bond, if you know?
That's what they told me. They gave it to me. They told me that's what it was when I was arrested, and I think they upheld it when I went to my 8.1, but I'm not sure who that was in front of. I'm not familiar with these judges. I've never been in trouble here.
Mr. Carter, what do you recommend for bond?
Judge, if the $35,000 is only on case 2018-230, we could certainly reduce it to $7,500. If it covers all 3 cases that she has, and again, I don't have the other 2 files, so I don't know what those charges are, but a $35,000 bond doesn't seem unreasonable.
One of my cases, Your Honor, has a no bond hold I'm trying to get lifted, so I know it doesn't include that. Is there any way that can be lifted? I was on bond.
No, I don't have those cases in front of me. They're assigned to another judge. I'm not going to review and reset bonds in a case that's not in front of me and I don't have any jurisdiction over. I have this case in front of me. I'll set the bond. I'm going to set the bond in this case only at $7,500 as recommended by the state. That'll be the...
I think that one was 5,000 by itself, wasn't it? She's looking.
Ma'am, I'm making the decision. I'm making the decision right now. I'm setting it at $7,500. So.
That's a higher bond, Your Honor.
No, ma'am. I don't have any record that it was ever $5,000. I'm looking at the records to determine this. So I'm not going to argue with you. I'm setting it at $7,500. That's where it's set. You may be excused.
If Jason Silva finds it's 5,000, can you reset it back at 5,000 so it's not higher?
No, ma'am. I'm not going to do that. We've dealt with it.
Summer is here and Harness Boots and Shoes has some of the hottest brands and styles available at great prices. You'll find a huge selection of sandals by Chaco for men, women, and children in various styles and colors. Birkenstock footwear sets the standard for comfort, quality, and functionality and continues to be one of their most popular brands. New for the season is their Tony Lama casual shoes for men and boys and the all-new Ariat Cruiser Classic slip-on for women. Their selection of Twisted X continues to grow with the latest and new styles. Get in the swing of summer at Harness Boots and Shoes on the Square in Harrison.
Introducing the revolutionary Vet Gun, a fast and easy insecticide delivery system for controlling cattle parasites. Vet Gun is so quick and easy, you can shoot it while on foot, on horseback, or from the comfort of your ATV or vehicle. And you can treat up to 100 cattle in as little as 1 hour. The new Vet Gun delivery system provides minimal stress and maximum gain for both you and your cattle.
Get your Vet Gun system today at Quality Feed Grains in Harrison.
You know, we should always remember to have a working smoke detector where we sleep. Let's go, let's go. Okay, we're all safe, we're all safe. In an emergency, you need a meeting place outside the whole family can meet so that you know everyone is safe.
2018-62, State of Arkansas versus George Woodworth.
Your Honor, at this time, I'd ask if we could set a new date for the pretrial. I believe there'll be a pretrial motion made.
Okay.
And I'd also take the issue of bond at this time.
This is a case. This case is set for jury trial during the week of August 6th, and today was the date set for jury trial, and that's the defense is moving, set for pre-trial hearings.
And the jury trial can remain in August, Your Honor.
Well, that's going to be the problem, is where
we'd have to put it on August 3rd, I would think, because well, we could do it on the 13th, but I could tell you the docket already is 5 pages long.
I know that, and that's why
The only thing I can find out about his bonds at $35,000.
I'll set the pretrial date as August 3rd.
He wrote it. August 3rd, Your Honor?
Yes. So that's both the plea deadline date and the pretrial date at this time. Any other matters to be taken up on this matter?
Judge, we asked for a reduction in bond. At this time, I don't believe Mr. Carter has anything on bond. My notes reflect that he has a $35,000 bond. And we'd ask for that to be reduced. Your Honor, I believe he has employment or has the ability to gain employment. We'd also state to the court that he would no longer drive, as this issue stems from a vehicle accident, and that he'd meet with probation and parole on a weekly basis if needed, and also wear an ankle monitor. I don't believe he's a flight risk. He's lived in the area. He's had a residence in the area. But this is a fairly complicated case, and I'd like to meet with him at the office if possible.
We didn't mention no drugs or alcohol.
That's fine, no drugs or alcohol. That's the whole reason he'd be meeting with probation and parole. And he could be on weekly drug and alcohol testing.
Does the state have any record of what bond was set in this matter? I mean,
we talked about that this morning. I couldn't find where my notes don't reflect the bond being set. There's nothing on any paperwork.
The only thing I have is what my client gave me on his questionnaire.
Mr. Webb, Judge Webb, you set my bond back in January, $35,000 cash and pro. And I'd also ask if I do make bond, if it's possible that I bond over to Berryville so I can go to work at Freedom Seekers. Because because I'd like to be able to go to work, and I can't drive, obviously, so they insure a ride to work, and I've already been accepted over there, and I've got a job waiting on me as soon as I get there. And I won't let you down. I'm gonna get this right, Judge. I think I wrote you a letter, Judge. Did you get my letter?
I believe I saw a letter in my office. I get so much correspondence, I can't say for sure. So you're not the only one who's tried to communicate with me in that regard. But it is, you're represented by an attorney. Technically, it's inappropriate for read any letter from you in this circumstance. Your communication with the court needs to be through your attorney. It's just a matter of law. So, you know, I'm not going to independently consider something I get from you if it doesn't come through your attorney. So, now, what is the request that's before the court for a bond? That's your other guy.
Your other request would be a reduction in bond somewhere around $5,000 to $10,000. Ankle monitor, weekly meetings with probation and parole for drug testing, alcohol testing, remain gainfully employed, and remain in the area or in Berryville. I don't think he's really got anything. He might have a DWI from a long time ago, but he's got a DWI from 2009. That's a long time ago. He refused the test. That's no big deal. And no driving, Your Honor. His license will be revoked. I believe his criminal history is very minimal. And I don't believe he has any felony history.
That'd be correct.
Does he have a DWI history?
Yes.
From 2009.
Please make my bond $5,000. I might be able to get Mr. Campbell to let me out where I can go to work. And like I said, I won't make you look bad for letting me go, Judge. I'll take care of everything and I'll make it right.
You may be surprised to know that I've heard that before. The court is not going to reduce the bond at this point. I'm sympathetic to the need to get ready for trial at this point. But given the fact that the individual has a prior history of DWI, and at least that's part of the allegations in this negligent homicide case, the court's not willing to assume the risk that this, regardless if it's a condition of bond that he not drive, that this individual won't drive, so I'm not going to reduce the bond. We're close enough to a resolution of this case by trial or otherwise that the court's not going to reduce the bond. All right.
Thank you, Judge. I appreciate it.
All right. You may be excused.
Thank you.
In Court on TKO8 Television is brought to you in part by Campbell Bonding Company.